Thank you, Mr. Speaker. And it's my honour today to rise and speak to Bill 2, the Protection of Public Participation Act. And inasmuch as my colleague from Saanich Northing Islands was brief, I may go the other way. Because this is an act, this is a piece of legislation that speaks to a very personal experience for me and my community. And I'm going to tell this story, and I've told it many other times in this House, but the reason I tell this story over and over again is because it relates to so much of the work that is happening in this House under this current government. So from the very beginning, the Shawnigan community was abundantly and consistently clear we did not accept the risk that a contaminated landfill posed to our watershed and our drinking water. Right back to 2012, the community had been standing up and saying no. The Shawnigan Residents Association hired independent scientists to assess the proposal, the site, and the engineering, and their opinions were clear. This was an unsuitable location, and the landfill would indeed pose a threat to our water quality. The community began its efforts to engage with the provincial government right from the outset. Hundreds voiced their concerns at a public meeting in July 2012, and hundreds more wrote letters once the draft permit was issued. Citizens John and Lois Hayes and Rick Saunders filed their own appeals of the permit when it was issued, along with the Cowichan Valley Regional District and the Shawnigan Residents Association. The Environmental Appeal Board hearings took 31 days over 5 months, and many of us attended and watched online, learning about the serious concerns of the independent experts. We were also shocked by what we perceived as blatant unfairness during the hearings, particularly when the panel refused to allow evidence or to hear witnesses that were brought forward by the Shawnigan Residents Association. Indeed, we were vindicated in this 4 years later by a BC Supreme Court ruling by Justice Sewell, who wrote in his ruling to answer the question, did the Environmental Appeal Board act fairly in its treatment of opinion evidence? Section 96 of his ruling, I have concluded the board did not act fairly in the manner in which it received opinion evidence in this case. We waited 8 months for the Environmental Appeal Board to make its decision, and when it came on a Friday afternoon, it was a devastating blow to our community. But we didn't give up. We geared up. Nearly 300 people came to a community meeting on March 24, 2015, and we decided that we would work together as a community for as long as it would take. After the Environmental Appeal Board hearing decision, 15,000 signatures were collected, hundreds more letters were written, and rallies and protests began. The opposition to the permit was overwhelming and the support was non-existent, but that in no way swayed the provincial government. All of our pleas, our evidence, our research, and our efforts were dismissed over and over again. We felt the process was weighted against us, against independent scientific evidence, and against common sense. The process seemed to have a predetermined outcome, getting to yes, and it seemed that the predetermined outcome controlled the process. Consider what was lacking from the process that allowed a contaminated landfill to be put at the headwaters of our drinking watershed. Was there a landfill siting study? Nope. Was there an independent environmental assessment? Nope. Was there equal weighting of scientific evidence that conflicted with that of the engineers hired by the company? Nope. Was there consideration of the previous actions of the proponents, including non-compliance with their mines permit at the very site? Nope. Was there consideration of the experience of the proponents or their engineers with designing, engineering, and managing a contaminated landfill site? Nope. Was there consideration of the opposition of the Cowichan Valley Regional District, Island Health, Cowichan Tribe, Shawnigan Community, the Capital Regional District, and the City of Victoria? Nope. Worst of all, when it was revealed that Active Earth, the engineers who assessed the site and designed the landfill, were in a 50-50 profit-sharing deal with the owners of the site, the Ministry of Environment did nothing and allowed the soil to continue to be imported to the site. Their excuse, the matter is before the courts. The result of this inaction, there is currently over 100,000 tons of contaminated soil sitting in a quarry at the headwaters of our drinking watershed, leaching into our environment. And so as a community, we felt that we had no choice but to stand up for our watershed, which we did for years on end. The effort crossed all lines, including political. The sitting NDP MLA, the sitting federal NDP MP, the leaders of the BC Green Party, the federal Green Party, the candidate for the BC Liberal Party, support from Cowichan tribes, from the Cowichan Valley Regional District, from the City of Victoria, and many others. And the campaign to protect our watershed engaged the entire Shawnigan community and was supported across the province and indeed across the country. And ultimately, the permit that we so vehemently opposed was revoked. But before that happened, Justice Sewell of the BC Supreme Court issued a ruling in a judicial review that had been brought forward by the Shawnigan Residents Association. We as a community had been deeply concerned, obviously, about this permit, and Justice Sewell also expressed his concerns. And this is reading from his decision in January of 2017. He says, the existence of a financial benefit to the qualified professional from a particular outcome is a clear example of a reasonable apprehension of bias in the person preparing the opinion. He said, if the question before me had been whether to set aside the permit, I would have had no difficulty in setting aside and remitting it to the Ministry for reconsideration because the technical assessment report was prepared by persons who were biased in favor of approving the project. He also wrote, this is a circumstance that goes to the heart of the integrity of the approval process under the Environmental Management Act. A Supreme Court judge of BC identified what happened in Shawnigan Lake as going to the heart of the integrity of the approval process of the Environmental Management Act. There is a part of the story of Shawnigan that didn't make a lot of headlines. Community members, single mothers, grandparents, professionals, long-standing volunteers were getting knocks on their doors. And when they opened them, they were served with documents notifying them that they faced a lawsuit. One woman told me in tears that she'd never even had a parking ticket in her life. On one occasion, after a community meeting in the village watershed office, people were greeted by a process server as they left the meeting, each of them served with court documents, telling them that they were going to be sued for what they were saying to protect their own watershed. For the people of Shawnigan who wanted nothing else but to protect their drinking water from potential contamination, these documents had the intended effect. They created fear, a fear of speaking up, of speaking truth, of standing up for the future of our community. And it created a chill in Shawnigan Lake. At the same time, journalists were receiving emails from lawyers. As the Attorney General pointed out, this is not uncommon. And the letters were threatening the journalists that if they continued to report on this story, they too would face legal action. And so while we stood for years and years telling the truth about what was happening to our community, about the unfolding events that strike at the heart of the approval process of the Environmental Management Act, we were facing, as a community, this threat. Ultimately, when the permit was revoked, we are now left with more than 100,000 tons of contaminated soil at the headwaters of our drinking watershed. We remain steadfast in our commitment to seeing that soil removed. It never should have been deposited there in the first place, and it needs to be put in an appropriate location, not in a quarry halfway up a mountain with a creek that wraps around it that feeds directly into the lake that is the drinking water source for our community. But what should never have been taken away from our community was the right to stand up and speak out on behalf of our watershed and our future without the fear of being sued. The legislation introduced today will ensure that communities across BC will be able to speak up and speak out when they feel that their future is put at risk. A democracy is built on a foundation of trust and the rights of citizens to be able to speak up and speak out for their future and their children's future. And I applaud the Attorney General for bringing this legislation forward. I look forward to the debate at committee stage. Thank you very much.